Bismillah ar-Rahman ar-Rahim. Assalamu alaikum. Welcome back. It is exactly 9 after 8 o'clock on News and Views this Tuesday morning. Now, standing by to talk with us this morning is Zwanele Manyi. He is the spokesperson of the Jacob Zuma Foundation. Now, we know that the Gauteng High Court in Johannesburg has granted Cyril Ramaphosa an interdict to halt the private prosecution brought by former President Zuma. And we are told this is a travesty of justice by the foundation. Spokesperson, who is Zwanele Manyi, was addressing the media yesterday after the judgment was handed down. So we're going to now hear what is the way forward as far as Zuma's lawyers are concerned. Obviously, they're going to map a way forward. And why do they believe that this is a travesty of justice? Zwanele, a very good morning to you. Welcome to the program.
Good morning, ma'am, and good morning to your listeners.
Thank you for your time. Do appreciate it. So we understand that the foundation is taking particular exception to the full bench's assertion that the civil court had, this is one of the points of contention, obviously, that the civil court had jurisdiction to adjudicate on the matter, even though Zuma had instituted a private criminal prosecution. And of course, we understand that it wasn't treated as a private criminal prosecution. Would I be correct in having shared that statement?
You're correct indeed, but there are quite a few things.
Okay, I can't hear you at all. You're very, very soft. Could you speak directly into the phone, please?
Okay, can you hear me now?
It's just a little better. Let's.
Can you hear me now?
It's not much better, Zwanele.
I don't know now what was said.
Okay, there you go. I'm raising the volume on my side to see if we can hear you. Okay, over to you now. It seems to be a little better.
Okay, can you hear me better now?
Perfect, absolutely perfect. Thank you.
Okay. Quite a few things that we found very glaring in that judgment. Firstly, let's just settle one thing: that the supreme law of the land, the Constitution, is the supreme thing that everyone must adhere to, including judges. Judges are not above the law. Judges are not above the Constitution. Now, for starters, if one looks at Section 34 of the Constitution of this country, it talks to the issues of balance of inconvenience. That if that is an issue, the issue must be settled in court. But this bench decided to even violate that principle, that right in the Constitution of settling things in court, and they decided to side with a criminally accused person that things can be settled. Basically, a person must not go to court. So that's the first issue. Very glaring that this bench acted in a manner not consistent with the dictates of the Constitution. That's the first thing.
Okay, so basically what you're talking about there, as per your media statement, is that the Judge President, Gauteng Deputy Judge President Roland Sutherland, who delivered the judgment for the full bench, you are saying, and the foundation is saying, that they need to explain why is it that when it's a criminal court, I'm just trying to break it down and simplify it for the benefit of myself and our listeners. So you're saying they wear red robes, and when it's a civil case and they wear black robes. Why is that significant if a court is a court?
Yeah, okay. That is the second point. The first point I'm making, just to summarize, the first point I'm making is that going to court is a bit of an inconvenience. But I'm saying the Constitution has ruled already on this matter where you have to weigh the balance of inconvenience between the accused person and resolving the matter in court. The Constitution says go to court. These judges say, no, don't go to court. So I'm saying the first thing is that they violated a constitutionally enshrined right of settling matters in court. That's the first thing. The second thing is that that court was sitting as a civil court, not as a criminal court. And we argue as the foundation that the fundamental difference between a civil court and a criminal court are the standards they used to decide on matters. In a civil court, the yardstick used is balance of probabilities, which is a much lower standard than what is used in a criminal court, where you have to prove beyond reasonable doubt. So this is the issue. So if a case is scheduled to be discussed or argued in a criminal court, in our view, we don't think that a civil court can decide that no, using their own standard, and say no, that matter may not even sit as it were. And in a criminal court, the Constitution, again, Section 35, including the Criminal Procedure Act, Section 158, require the accused person to be present in court. This is the law. Now you have this court here that makes a decision to say a person should not be there, you know. So it's very problematic.
Okay. Mzwanele, what I'm hearing from you is that the suggestion is that the full bench that listened to these arguments were very biased. They were biased towards Ramaphosa. Is that what you are trying to indicate here?
Indeed, I'm saying not only were they biased, but they were biased in a manner that in itself violates the law. You see, another point is that in the constitution of this country, we know we all have the rights and all of that, but it's not a debate that the rights that we have limitations. It's not absolute rights. The only right that is absolute is right to life. So if we have a court that says if President Ramaphosa goes to court, he will suffer irreparable harm, how can that be? Because if he goes to court and argues the matter and the court acquits him, whatever harm would have been there would have been repaired. So why is the court saying this is irreparable? It's not like he's going to die and therefore can't wake him up. That is irreparable. But the person going there with a contention that he's innocent, yes, he'll be treated with suspicion up until the court process is done. But once the court is done, once he's acquitted, what harm is there that's left? You know. So in our view, this court has really misdirected itself because the court had to do everything in its power to favor President Ramaphosa, to protect President Ramaphosa. So we summarize the whole matter as saying we don't have a blind lady justice. This justice looks to see who is before it and therefore what decision must be taken, not based on the facts, not based on the law, but based on who is on the dock. And we think that is a travesty of justice.
Okay, so now let's just look at this issue from Ramaphosa and his legal team's viewpoint. We know that you, as Zuma's lawyers and the foundation, are busy contemplating your next move. On the other hand, Ramaphosa has welcomed the judgment. It must be quite a relief for him and his legal team. And in a statement, the presidency has said that the court had affirmed all the contentions made by him. And I quote, this is what they go on to say: the judgment confirms the position of the president that the private prosecution is motivated by the ulterior purpose based on spurious and unfounded charges. This constitutes an abuse of private prosecution provisions and demonstrates flagrant disregard for the law. And I unquote that. So, how do you respond to that?
No, I think that was an opportunistic statement to mislead the public. You can only make that statement when there's a finding against the assertions by President Zuma. As we speak here and now, there is no finding against the quality of the knowledge prosecute certificate. There is no finding against the summons. So you can't make the kind of statement that the president is making. They are just misleading the public once more. You know, there's no finding on these things. How do you then say you're vindicated when there's no finding in your favor? This thing is just saying, hang 10. Let's first discuss this thing. Take part B. What we're dealing with there are issues that still need to be argued on part B. It's not a finding. These are issues in dispute. This is why you need to go to court to resolve these matters. So you can't take a shortcut and say the interdict means you were right. Doesn't mean anything.
Okay. Let's look at two issues here, which I believe is very important for lay people to understand, including myself. Number one, I had never ever in my life heard about private prosecutions, but we're hearing now for the first time, for me anyway, in South Africa, that there is that route open to people. If it's, to me, it suggests that if I don't get satisfaction in a court of law, or if I don't get any satisfaction if my case is heard or not heard or thrown out, I can go the route of private prosecution. How serious is that matter? How serious should the matter be for a layperson to go the private prosecution route? And how costly will it be for the person to undertake private prosecution? Let's understand that, how favorable that sort of a situation is for South African people.
Okay, let's start here. The issue of prosecuting anyone, first and foremost, is the sole preserve of the NPA, the National Prosecuting Authority.
Mm-hmm.
Now, the only time that the private prosecution issue kicks in is firstly when the NPA has looked into the matter and has decided that they are not, for whatever reason, then they decide that no, this case is not strong enough or whatever, and therefore they are not going to take their case to court. And you might strongly believe that no, your case is actually very strong, is watertight, that maybe the NPA is playing political games, that you therefore want to take the matter to court yourself and assume the role of a prosecutor. Now, in that case, before that happens, then the NPA must issue you with a certificate. This is called a non prosecutor or none, or rather in a much more straightforward English, and not a certificate not to prosecute. So they will then declare that they themselves are not going to prosecute on this matter for various reasons that they have, and therefore over to you. Now, in that case, you then become the private prosecutor with virtually, I think the only power you don't have as a private prosecutor is the power to arrest. But the rest of everything that the NPA can do, you can do as a private prosecutor. Then it's an expensive exercise, because as you do this private prosecution, if, for instance, it turns out that you were wrong, therefore there must be costs that you must pay. Already, you must have provided for those costs. That's really all the thing there is to it. Maybe the side that we're dealing with is a rich side, and it's going to still tell you that they've got 2 counsels and so many attorneys and so on. Their bill is estimated to be R1 million. The registrar of court will look at that and determine whether how much deposit should you put in there. You can also argue against that and all of that, and you might maybe get away with putting, let's say, 300,000 or something in the kitty just in case you lose the case. That's how it works. So it's actually, truth be told, it's an indictment on the NPA that you are beginning to have growing cases of private prosecution. The first person in my understanding in this country that ventured into this is Gerinel. Gerinel used to be a very powerful state prosecutor working within the NPA, but he decided to run his own practice as a private prosecutor. That should tell you something. That should mean that Gerinel is a genuine person, is a person that does not politic around law issues, is a person that chases evidence, not people. So you must have come to a conclusion that NPA is veering its mandate. It's doing political prosecution. I mean, look at what NPA does. NPA can come and arrest you today and then say, for the next 2 years, they are busy investigating why they arrested you. I mean, what kind of nonsense is this? They do that religiously in NPA. They take you and they show you up in court. They get taken pictures and everything. 2 years later, they still don't know why they arrested you. Then they're saying they're investigating. In that period, your name is dragged in the mud. So that's
your life is destroyed in that 2 years, obviously.
In that 2 years, exactly. So that's the kind of treatment that you get in NPA.
Thank you indeed for that background information. It makes so much sense. I'm wondering, to your knowledge, and I'm just digressing a bit here, have we had many private prosecution cases going to court? And if you have followed any of those, do you believe that they've been dealt with very fairly and justly? And how seriously does our judiciary take these private prosecution cases?
No, they're quite serious. For instance, the Thandi Modise, at the time she was the Speaker of Parliament, and here the case, not even, it was something about in her farm, treatment of pigs, imagine.
Oh yes, I remember that case. Case.
That's that. And then the NPA did not want to prosecute, and then Gerinel decided to privately prosecute Thandi Modise, and it went to court. And Thandi Modise did not say, I'm too important, I'm a speaker, this is going to impugn my integrity, my rights, my liberty. Right now, everybody has forgotten about that because in that court case in particular, Thandi Modise actually won the case.
Wow.
But today, she won the case. And today, nobody talks about her in bad light because she won the case, you know? So it works.
Yeah, all right. Mzwaneli, obviously you're an advocate in your own right as well. You really know what you're talking about.
No, I'm not.
Aren't
Please,
you? Oh, okay.
no,
Are you an attorney? Are you an attorney? You have such deep legal knowledge.
Nothing. I just read
a
lot.
Wow. Congratulations. You're very, very well read. Okay, let's look at the issue here. Look, we know that Jacob Zuma was the past president. Ramaphosa is the sitting president. They represent the same party, the ANC. They may have slight different views. They may be in different factions of the ANC. The one may be RET, a very staunch RET a follower. The other one may not be. And you can guess which one I'm referring to. Could this matter not have been then settled privately because they are comrades in a sense? Things might have soured, between them over the past few years. But the fact of the matter is they do represent the same party and they have been comrades for a very long time.
I think a confusion must not be made here. We're not dealing with the petty political issues within the ANC. We're dealing with issues at a state level. This is what happens on the government level. So at that level, there's no comrade. At that level, it's what you need to do as the president and also what you need to do as an individual. This is not a branch issue or or a list issue or anything intra-party. This is something at a citizen level, and citizens interact with the state. They don't interact with the political party. That's just your private membership thing. But as a South African citizen, you respond to the legalities of the country.
Okay, my final question then, and even though I referred to you, I presumed that you might be a legal eagle. You may not have the necessary qualifications, but undoubtedly you do know your stuff. You definitely come across as a seasoned legal eagle. Now, the issue at stake here is the accusation by Zuma against advocate Billy Downer and News 24 journalist Karen Moore of leaking Zuma's confidential medical information during his arms deal trial. Downer and Moore have subsequently lodged applications to have the private prosecutions declare an abuse of court processes, and that is why we now understand why Zuma went the private prosecution route. That being said, where and how does Ramaphosa feature in all of this? We have heard rumors that Zuma reached out to Ramaphosa to intervene in this matter, and Ramaphosa did not intervene. And that is why uh, Zuma then went the private prosecution's route. And there's a very big, there's a terminology that is being bandied about, and that is, and I quote, after the fact. So explain all of that to us. And is Ramaphosa truly, guilty of this after the fact issue? And should he be implicated as far as the Billy Down and Karen Moore situation is concerned?
Yeah, thank you very much. Firstly, I must thank you for the accolades. Yeah, Rogue, here's the situation. When a person is guilty, you are guilty. There are two categories. You can either be guilty by committing a crime, or you commit a crime in two ways, by commission or by omission. So those are two broad categories that people must understand. See, for instance, right now, I'll get to a question now. As part of also this duplicity of this court, Ace Mahashule, as an example, is charged for lack of oversight. This is something that he did not do. He's been dragged to courts for the past 2 years now for something that it's alleged that as the premier, you did not exercise your oversight. He's in court now. But this court today has forgotten that and is now saying, no, this would be interference and all of that. It's exactly the same category of issue, that if something happened, you should have done something about it. You're not doing anything about it. As Mahashule, we are in court. But when the same applies to President Ramaphosa, they say it's a novel case. It's a new thing. It's the first time they come across this. Yet somebody is busy in court on the exact same issue. But let's bring it home. Here you have a situation where, to make it easy for somebody listening, if you have somebody robbing a bank, that person is the perpetrator. And if that person takes the money and then there's a getaway car that's waiting outside, the person that's going to drive the getaway car is an accomplice. All right? This will be on the date 9th of August 2021. This crime happened. You are sitting in holiday somewhere as the head of state. You're not even involved in this. So that's the ticker box. And then 2 weeks, 3 weeks later, you get reported to you that, man, something bad has happened here. And only in the country, you are the only person with the power to institute an inquiry. You see, for instance, the Zondo Commission was signed off by the president. The party commission was signed off by the president. The Murane Commission was signed off by the president. Then you say, with that power you have to institute those kinds of inquiries, can you put an inquiry in this? Because what has happened in the criminal justice system can impugn or rather will damage the credibility of the entire criminal justice system, because the case here, the perpetration of the issue here is that those documents, let alone what the contents were, let's deal with the principle. If, as NPA employee, you take documents that are still part of the investigation and you give them to journalists, you are committing an offense in terms of the NPA Act, Section 41, Subsection 6. You're committing an offense if you do this. Now, if you then report that offense to a head of state to say that's because you see those documents, the argument that those documents were public and whatever, is not true, because at the time when they were leaked, they were not public. Even the affidavit of Billy Downer was not even commissioned yet as evidence that these things were not in the registrar of court. They were still very fresh. They were still dealing with it. It was sharing notes and sharing this and sharing that. That was still all part of what was eventually going to end up in court. But at the time it was leaked, it was not public information. But that's a separate set of issues. Here,
okay, we're running out of time. We're running out of time. I'm getting a lot of feedback on my side as well. But can I just give you a minute very quickly to wrap up, please?
So the case against President Ramaphosa now has got nothing to do with the perpetration of being an accomplice. It's got to do with being an accessory after the crime. So he is being charged for what he should have done, what he didn't do. Whether he's guilty or not, only a court can pronounce on that. We cannot say he's guilty of that, but to have a case to answer in terms of that. Now, the court on the 19th of January was meant to give him an opportunity to answer to this question. But we have this other court here that says no, he must not go and answer. So that's it.
Right. Zanele, undoubtedly you and I are going to talk lots more about this. So it really comes down to the statement you made earlier, commission or omission. So this is a situation of omission on the part of Ramaphosa. But listen, I have to end it there, unfortunately, till the next time. Thank you indeed. It was wonderful talking to you. Go well.
Okay, thank you.
It is exactly 8:36 a.m. News and views right here on Salam Media. Standing by to talk to us from the other end of the world is journalist and research scholar based in India, Asif Mujtaba. Please stand by for that interview.